Copyright in these lectures is either owned by the ANU or a third party who has licensed the ANU to use it. Students may use the recording for personal study only. No lecture may be communicated online, copied or shared without the prior permission of the ANU.
Okay everyone, we'll just get started. Welcome to your last lecture for 7052. We're just going to finish off with just a very few slides from the intellectual property lecture last week. There's only a couple of slides left. So these slides were not included in the package for today. They're starting at slide 68. There's not much content. I'll just go through that now and then we'll finish off the week 12 lecture with revision. So if you have a client who feels like their trademark has been copied by someone else, but they haven't actually registered that trademark under the Trademarks Act, which means they don't have any of the protections that are afforded to those who have registered their trademark, I mentioned last week you might want to consider whether they might be able to bring an action in the tort of passing off at common law. So that is one option for someone who hasn't registered their trademark, and another option is that they might bring an action for misleading and deceptive conduct under Section 18 of the Australian Consumer Law. Your notes on Section 18 of the Australian Consumer Law, I think we talked about it in week 8 or week 19 of the course, and I've got a federal court case there for you regarding the use of the colour purple by Cadbury, Schweppes and Darrell Lea. Cadbury unsuccessfully sued Darrell Lea in relation to the use of the colour purple on its chocolate products. So both these companies were wrapping their chocolate bars in purple wrappers, and Cadbury was unhappy about that, so they brought an action against Darrell Lea, and I think there was a counter-sue. Anyway, Cadbury was unsuccessful in Australia in convincing the court that Darrell Lea was engaging in misleading and deceptive conduct for the use of purple. However, relatedly, in the United Kingdom, Cadbury was successful in getting a trademark over a particular shade of purple. So purple is a sign under the Trademarks Act, a colour, so it is eligible to be registered. but of course it can't be registered if it would be deceptively similar to another product in the same market. Okay, so these bits here are really for you to have a little note for yourself. If in an exam you were given a question that looked like a trademark question, except the individual hadn't registered their trademark, then you wouldn't be able to talk about the protections afforded under the Trademarks Act, but you should talk about Section 18 of the ACL and also the tort of passing off, and consider whether the legal tests in both of those scenarios or either of those scenarios were met. Okay, and I just wanted to touch on confidential information and then we'll start our exam revision. So another option, you'll remember from last week that the 4 intellectual property pieces of legislation that I taught you, 3 of them require registration in order for any of the protections to be accessed. The Copyright Act does not require that. But if you found, either because of lack of registration or because something didn't meet the requirements in the Copyright Act, that there wasn't any protection, you might also consider whether the courts might, whether the person might be able to bring an action in the courts and ask the court to exercise its equitable jurisdiction to provide a remedy for your client. And this would be on the basis of a breach of confidence. And the test that would need to be applied is there. And I think we had an exam question in the 2017 exam where this test needed to be considered by students. So the information must be confidential. It has to be obtained in confidential circumstances. So perhaps someone whispering it to you or emailing it to you and saying don't show anyone, or just documents that were on a private company server, certainly not information that was published all over the internet. And then you also would have to show that the unauthorised use of that confidential information caused a detriment to the other party. Okay, so the other party actually has to suffer a loss. Okay, so the mere fact that you've used it isn't enough to make this test be met, unlike the intellectual property legislation. And your authority for that test is COCO. The type of confidential information that you would normally come across in an exam question would relate to the first category there. Information that has a commercial value, for example, trade secrets. Might be a secret idea for something that hasn't yet been patented, for example, would meet the category of confidential information. And the remedies, if you can prove that there has been a breach of confidentiality, include an injunction. So if the publication hasn't happened yet, it may be an injunction prohibiting someone from publishing that confidential information. There may be damages or an account of profits. The court could also make an order that the thing be handed over to the plaintiff or destroyed. Okay, so that's it. We can come back to these questions. I'd like to just go to the week 12 slides. So I'm hoping today we can get through both the 2018 and 2017 exam, at least looking at the legal issues. Your marks will be released tonight for problem paper 2. I've already put the answer guide on Wattle for those of you that want to assess before you've got your results what you should have written, or hopefully what you did write on your paper. And the average was again a credit. It was a slightly lower average than for problem paper 1, but perhaps the questions were a little bit harder than for problem paper 1. Certainly I'll be doing any scaling if I need to after the exam. But yeah, it was a credit average. Okay, so let's just go through a few bits of information about the exam. And I'm just going to edit this I'll put a post on Wattle for those of you who weren't here today. I'm actually not going to be testing you on statutory interpretation, so you won't be assessed on any of the content from weeks 1 or 2. But I'll put that on Wattle. I've just noticed I did have an exam question last year that had statutory interpretation, but I won't assess you on that in the exam for this year. So you need to be looking ahead. Sorry, I think I might have uploaded the wrong slides for this. So weeks 1 and 2, I'm just going to write it here, but I will also clarify this on Wattle for you, so that there is no doubt. So, of course, you need to understand the material in weeks 1 and 2. I think week 3 is not accessible, but I will put a post on that tonight. There might be one question on negligence. Just going to email myself on that point. Okay, so the format will be, I just don't want to forget to do that particular thing, so I'm just going to email myself, update what is accessible. Sorry. Generally that material is accessible, but now that I've written the exam, I will be quite frank with you and tell you that there is no statutory interpretation question, just to save you the trouble. Okay. All right, so it'll be the same type of format as the 2017 and 2018 exam, which means there'll be 3 parts, and those parts will have multiple parts. So those parts could have 2 to 4 questions within them. Unlike some of the earlier years where you had to choose which questions to answer, all questions are compulsory. You need to do everything that is there. It's an open book exam, which I think you all understand by now. But ANU rules are that no electronic items can be brought in. ANU library books can't be brought in, and a photocopy of the book can't be brought in. But apart from that, everything can come in. Of course, you can bring in your tutorial notes, your slides, your own summaries, whatever. You can put stickers in your textbook. You can put notes in your textbook. That's all fine. Okay, has anyone got any questions about what open book means? Okay, excellent. Now, hopefully this isn't obvious. Well, hopefully this is obvious, but I'm going to say it because it happens every year that there's a student who does very well on the first 2 questions, perhaps even getting HDs, who then does not write anything for the 3rd question and may or may not pass. So be really strict with your time. If the time is up, move on to the next question. Okay? You have actually quite a long time to write. You have half an hour. Is this your first exam at ANU? A few of you? Okay. So I'll just explain what reading time means. So during reading time, you have half an hour to read the paper. But you're still allowed to write during reading time. So you're given what is called scribble paper. Okay? So you can still structure your answer, or perhaps write down your legal issues, or work out your times, or work out which questions are going to be easy for you, or which questions are going to take you more time, whatever. So you can still write on paper, but that paper, because it's not in the script book, isn't given to me. It sort of gets thrown out at the end of it. Okay, so you'll have half an hour to read the exam and sort of plan what you're going to do and how you're going to do it. Hopefully half an hour to reflect on how well prepared you are for the exam. And then you have 3 hours writing time. Not everyone is going to need 3 hours writing time, but if you need it, take it. That's fine. Okay, so that's 1 hour per question. I think that's a fair bit of time. But just be really strict with yourself and stop writing and move on to the next question. Okay, you will get so many more marks if you answer every question than if you answer some questions well and don't even answer others. Okay? All right, don't worry about making it look pretty. If you make a mistake, it's fine just to cross it out. But don't give me 2 options and tell me to choose. I'm sure you wouldn't do that. I've just had some students do that. You can answer in dot points if you're running out of time. Just be conscious of the whole course when you're looking at a question. So be particularly careful if you think the Sale of Goods Act, if you think it's a consumer law type question, make sure you also consider sale of goods. They both might apply, or maybe one of them won't apply. Okay. If it's a contract law question, also be aware of other parts of the course that might be relevant. Okay. Everyone deals with it their own way, and you've got your practice exams, so you can go through. I'd recommend trying to do a previous exam in actual exam conditions. But one good thing to do in the reading time is just to even work out what the legal issue is for each question. And some of them won't be obvious to you, but by writing down what you've already worked out and then thinking about the others, hopefully by the time you get to them, you'll have worked out what the issue is. Remember to think about defences and remedies as well. Sometimes I will narrow the question. So the question might say, what action can, I think I've said Sarah, but what action can Sarah take in contract law? Okay, so that's telling you only look at contract law. If you start writing about Australian consumer law, you will get 0 marks for that. Okay? And sometimes I might say, don't look at section 18 of the ACL. So if I exclude things, don't write about them. Okay. Now, exams, I'm talking a little bit fast because I'm really keen to get to the actual exam questions. But exams are, in a way, I think, easier than the problem papers because the presentation standard is a lot lower. Okay, and you're doing a lot more in a lot less time, so your answers don't need to be as long. You don't have to write the full case name. You do definitely need to make sure, if you're talking about a legal principle, that you have some legal authority, case or legislation for what you're saying. Those rules still apply, but you don't need to have footnotes and you don't need to write the full title out. So I've got 2 examples there for you. So the Donoghue and Stevenson's case, you could just refer to as Donoghue, for example. Section 18 of the Australian Consumer Law could be S18 ACL. Now, I put that first sentence there to assist students, although unfortunately sometimes it confuses them. All I'm trying to say is it's helpful for your marker if you can distinguish the law for them, the legal authority for them when they're reading. So it could be useful to underline it or put the case in brackets. But you don't have to. Neither of those are rules for about how you need to do it. Okay, but you definitely still need the specific section of the Act, so the particular number and the name of the Act. There is no bibliography. Okay. A number of students, not all students, but quite a few students repeated the facts of the question in their answer for the problem question as sort of like an introduction. Don't do that because your marker knows what the facts of the question are. They have the exam paper and you don't get marks just by showing them that you can copy them out. Okay? So don't waste your time doing that. The only time you should be mentioning the facts is when? What part of your answer should you be talking about the facts? In the application. Okay, when you're applying the law to the facts, you need to be talking about what's happened in that factual scenario and what that means, okay, for your conclusion. Okay, so it doesn't matter how long your answer is. Your answer should really be as long as it needs to be to answer the question within the strict time limits that you have, okay? But certainly you're not going to get extra marks for a long answer that doesn't answer the question. Okay. I feel like I've made that point already, but yeah, don't put in things that aren't relevant. So let's come up with an example that you are all familiar with, hopefully. So section 29, subsection 1 of the Australian Consumer Law that lists all the different types of misleading conduct. Only mention the specific subsection that's relevant to answering your question. Don't mention all the other ones that aren't relevant, okay? Okay, so these are the exam consultations for next week. You can, of course, email me if you have any questions as well. I think it's really good. Like, there's something for you every day next week. I'm sorry that my consultation is so early. I was saying to some students this afternoon that I usually consult on a Friday afternoon, which next week would not be appropriate because you will all be in your exam. So even though I have that early consultation, I'm still very happy for you to email me if you'd like to, and you certainly have a lot of access to tutors, at least 3 hours every day. The tutors also have the past exam papers, so they can give you some tips on answers that you have prepared. And what was I going to say on top of that? Oh, I've also put this on Waddle if you want to check it out. You would have all got your CELT invitation in your email. I encourage you to do it. I think you can even do it. I think they're still open even after you've done the exam. So if you're feeling too busy to do it right now, you can do it a little bit later. I don't see it until you have all got your marks back. And it's always anonymised when I see it. I just see the aggregated data. So it's a very, I think, safe, anonymous way for you to tell me what you think. Of course, you're welcome to send me an email if you've got any improvements you'd like to give to me that way. But otherwise, do the CELT. All right. Does anyone have any questions about the exam format or what to expect on the day? Yep. Is it what? A double pass? Oh, do you have to pass the exam to pass the course? Is that your question? I did have a slide on that and I removed it. Because I'm hopeful that the fact that you're here today and you're engaged today, you will not need to be worrying about such things. Where is the unit out? Well, just quickly check the course outline. I think you have to pass. Maybe not. Let me just check. Feedback, policies. Okay, so all components are compulsory. To achieve an automatic pass grade, you have to obtain 50% more as an aggregate mark, so that's your total mark for the course, and a minimum of 40% in the final exam to pass the subject. You guys will be all right. It'll be fine. You've already done 40% of your assessment, so anyway, yep, so that's it. I'm hoping nobody is planning to get between 45 and 49 as an overall course mark, but if you do get between 45 and 49, you would have an opportunity to sit another exam, which perhaps simply so that you don't have to sit another exam, you just need to study that little bit more to make sure that you get 50 and then you're done. But yes, there is sort of a saving grace opportunity there for those students that get between 45 and 49. The really, I think, terrible thing about that though is because it's a semester 2, that exam would be held in February 2019. So you're not going to have a very relaxing summer if that's what happens. But yes, there is that opportunity. So hopefully that answers your question. Yep. Does anyone else have any questions about the exam? I think they're in 2 different rooms. So just check. I think you would have got your own email telling you where to go, but your friend might not be. If you're the sort of person who likes to just get your friend to tell you where you need to go, just check that you're in the same room because they're not in the same space. I will be there and I'll be available for the first half hour if you have any clarifying questions about the paper. Yeah, please turn your mobile phone off. Someone's phone always goes off during the exam, which is really annoying. Does anyone have any other questions about the exam? Okay, if you've got more, ask me or send me an email. I think I've probably covered off most of it, I hope. Now, we can close our week 11 slides. Now, a lot of from current side, a lot of the 2018 questions you've already done in tutorials, but I can go through them again. Does anyone want to go through all of the 2018 questions again, or would you just like to do the ones you haven't done yet? Or we can start with 2017. Hang on, just give me a moment to find all my notes. All right, we might just start with, what have we got here? 2017. Okay, so I'm just jumped ahead to 2018 question 1A. So all of the 2018 semester 1 questions were set in a mobile phone store, and all of the exam questions for next week are set in the same factual space. So you won't need to get your head around hopefully as much new setting content. You can just focus on the law. Okay, now I feel like you've done this in tutorials, have you? But we can do it again if you like. Okay, so this is one of those questions where you're not actually helped very much. I've just said advise Patrick, so I haven't told you what area of law you should be looking at. Does anyone want to have a go at commenting on some areas of law? Australian consumer law, I can hear someone saying. What provisions of Australian consumer law might be relevant here? If you hear the person next to you saying the answer, if you want to say it for them loudly, and then you won't be embarrassed if it's wrong because it wasn't your idea. Unfair contract position. So you started off by looking at contract law? Yep. So what makes you think it might be an unfair contract? Yep. And because it's a contract where he probably hasn't had a lot of scope for negotiating the content? Yep. Yeah. Yeah, I think we can assume it's a standard form contract under Australian consumer law because it's a mobile phone contract. I have to admit, actually, because Kim sent this an example to me earlier, I didn't initially consider this as an unfair contract case, but I think it absolutely is, which is, I think, an example of how expansive you can be in thinking about the course. So I think you could definitely consider unfair contract provisions. I think also in contract law, we'd need to be thinking about inclusion of terms. If we assume that Patrick has signed the contract, what assumptions do we make that if someone has signed a contract? Yeah, so if you have parties have signed a contract, then the rule in Lestrange and Grab is that the parties have agreed to everything that is in that document, and that document represents everything that they've agreed to. You might also consider whether the text at the very bottom of the web page, this text about free data must be used between the hours of midnight and 4 a.m. You might consider whether that was part of the contract and whether it had been brought to Patrick's attention. Now, what I might do, just give you a couple of case names that you would look at. Can you read that? Is it a bit tiny? Okay, and then you'd also want to know whether the term about it only being used between the hours of midnight and 4 a.m, whether it had been brought to Patrick's attention. Okay, so those are the issues you'd be considering for contract law. What issues would you be considering in terms of Australian consumer law? Let's just go back to the question. Or are people still trying to write down what's on the slide? If you want to go back and practice this question, you can take it to your tutor during consultation for feedback. Now, can someone tell me what they think might emerge from these facts from the basis of Australian consumer law? Yes, I can hear someone say misleading and deceptive conduct. Yep, in relation to price. Excellent. So, what provisions are we looking at? You could look at section 18, but you could also look at a specific, I think it's 29(1)(I). Okay, what about some case law in relation to price? Did anyone come up with a case that's quite similar to this case? It's about computers. Dell computers? Yep, excellent, well done. You're right, it's ACCC. I was just going to call it Dell. And also ACCC. It's actually quite similar as well to ACCC and TPG. And you can get that at 11.13 and 11.29. Okay, so, whoa, how do we get here? So I think you would, your issue is, has Audio Plus contravened the ACL by engaging in misleading and deceptive conduct related to price? And then you could say the fact that Patrick can't see what the price is. It's in very small font at the bottom of the web page. You need to scroll down to see it. Means that perhaps their conduct has been misleading and deceptive and Patrick didn't realise what the terms of that offer were. Okay? And what damages, what remedy do you think Patrick might get? Probably a refund, yeah. Maybe damages. Maybe they could change the term of the contract, which is what would happen with an unfair, if you found that it was an unfair contract. The courts, if possible, will keep the contract on foot. They wouldn't get him out of the contract. They'd simply change the term of the contract that was unfair, potentially. Okay. Does anyone have any questions about this? Okay. Patrick's going to have a lot of better remedies under consumer law than he is under contract law. Yep. I can't hear you, sorry. Paid advertisement. Oh, for as a remedy, adverse publicity order. Yeah, I guess so. You could, yeah, if there were a lot of clients involved and the ACCC brought an action in the court, you might seek an adverse publicity order. Yeah. Patrick probably isn't going to care about that though. Patrick's going to want a refund or for that term to be changed. But certainly, if you were asked to consider what Audio Plus might be liable for, then you would include that in your list. Yep. Okay, good. Oh, this is a fun one. I'm sort of jumping around a little bit. I think this was on page... I think you've done the RU question quite a few times, but we can pull it up if you want. This might be easier to do it this way. Okay. So you've done B. This is Rue, who's purchased a mobile phone to use in her accounting business. After 3 months, the mute button breaks and the ringtone is not audible. And there's a sign that says no refunds under any circumstances. Do you remember doing it in tutorials? Yes? You happy to keep going? Okay. Important thing to remember here is both the Sale of Goods Act and the Australian Consumer Law apply. Okay, even though she is using it in her business, it's still a consumer good. Okay, you've also done C. This one is about capacity. We said it was probably a contract for necessities. I think you'd be unlikely to meet a 16-year-old boy who didn't think a mobile phone was unnecessary. It's also about avoiding an ongoing contract. So the rule is that as long as Patrick seeks to avoid it while he is a minor or soon after he becomes an adult, then the contract can be void. But you've done that in tutorials, so go back and look at your notes for that. I think you've also done this one in your tutorials, the door-to-door sales question. Does anyone want me to go through it again now? Okay. I think that's a really easy question. So anyone who remembered when they were in the exam that there was a rule about door-to-door sales pretty much got a HD, because the law is not complicated to apply. All you have to notice is that it's unsolicited sales and check the time that the person's visiting, and remember that you can get out of contracts quite easily if it's a door-to-door sale. You'd be looking at section 33, section 82 of the ACL. Okay. Now you've also done this one in tutorials. Does anyone want me to go through it again? This is about Pranal trying to buy the latest mobile phone. If nobody wants me to go through it, I will just keep going to other questions, but jump up if you want me and let me know. Yeah, sure, that's fine. Okay, so on a recent holiday, Pranal saw some advertisements for the latest mobile phone. He asked the assistant, "Do you have the latest mobile phone in stock?" And the assistant said, "Yes, here is the latest model." Pranal buys it. And later on he realises he's bought the 7, not the 8, and Audio Plus refuses to provide a refund because what they gave him, they say, was the latest model. Okay, so the first question is whether Pranal can take action under the ACL or the Sale of Goods Act. Let's just think about it in jurisdictional terms first. Can he take action under the Sale of Goods Act? Is a phone a good? Yes. We can assume that it was bought for money consideration, which is the price. I'll just find you the provision for that definition. I think it's section 5, but give me one moment. It's the ACT dictionary that it's a contract for sale. And goods is defined again in the dictionary. So it's enough for your citation just to say Dictionary Sale of Goods Act. Okay. And let's just go through the sale of goods things. What action might he be able to take under the Sale of Goods Act? If you don't know the provision, you could tell me what the law is called. So we're looking at implied terms under the Sale of Goods Act. What's an implied term under the Sale of Goods Act that might assist Pranal here, perhaps? What would Pranal say? Pranal says, I asked for the latest mobile phone. You didn't give me the latest mobile phone. The good does not correspond with the description. Okay? Section 18, Sale of Goods Act. Yeah, Section 18, Sale of Goods Act. Okay. Now, I was talking to a student about this earlier in consultation. I think it's a bit of a tricky one, and it would be useful for you to show your recognition of this in your application. Okay? So Pranal is going to say it doesn't match, it doesn't correspond with the description. I want a refund, I think, is probably what he wants. What would the storekeeper say? Yeah. You never said you wanted the latest phone in the US. You said you wanted the latest phone. This is the latest phone we have in our store. Okay? What might Pranal say against that argument? Okay, we live in a globalised society. Everybody knows what the latest mobile phone is. It's the iPhone or the ePhone 8. You work in a mobile phone store, you should have known that. Anyway, I think there's room there for misunderstanding because Pranal perhaps wasn't as precise about what he wanted, but maybe the storekeeper should have known. So that's an example where a good answer would have looked at both perspectives and then possibly reached a conclusion or said if Pranal could show that the good did not match the description, his remedy would be a refund, for example. Okay? Now, what is the equivalent... Oh, I'm pumping on the mic, I'm sorry. What is the equivalent sort of thing for good does not match description in the ACL? So they're not called implied terms. What are they called in the ACL? Starts with G. It's a guarantee. Guarantee as to the supply of goods by description, and you're looking at section 56 of the ACL. Okay, I sort of jumped over the jurisdiction part. It would probably be okay in your question to say both the ACL and the SDA apply to these facts because the phone is a good and because a phone is an item that would ordinarily be acquired for personal or domestic use. Okay, and none of the exceptions to that principle apply. You could write that, that would be fine. Okay, so that's sort of your bread and butter answer. Some students perhaps might also consider whether they thought there was misleading and deceptive conduct. Maybe. But I don't think there was a lot of... There's nothing here to suggest the assistant was marketing things in that way. But yeah, you might want to talk about Section 18, Section 29 in your answer as well regarding ACL. Okay, I don't think that question's too hard, and if you go back and look at your tutorial notes, you can go over that in more detail. Your remedies are for ACL are in 260 and 261, and your remedies under SGA I mean, in both cases, he can really get a refund. I think that's going to meet his requirements. I might put it probably would assist you, I think, if I put a table up that had a split down of SGA and ACL remedies. I might try and do that this weekend. Okay, I think the more complicated part of this question is the second part, but I guess it depends what parts of the course you're most familiar with. But in B, you're asked, advise Pranal whether he can take any action in contract law. What do you think? I guess you looked at some of these issues in your in your problem paper, so perhaps you don't think this is trickier. So what would you be considering, perhaps? Mistake? Yep. What type of mistake? Yeah, I think it would have... Well, I don't think it could be unilateral mistake, because unilateral mistake requires one person to be mistaken and for the other party to know that. So I don't think here there's anything to suggest the shopkeeper does know that he's made a mistake. But I think if there was something to suggest the shopkeeper knew, then you definitely would be looking at unilateral mistake. You could be looking at perhaps mutual mistake, where both parties are mistaken as to the other party's intention. So she thinks he wants the 7, he wants the 8. And I don't think it's common mistake, because they're not mistaken about the same thing. Okay, so I think probably mutual mistake. You might suggest there was innocent misrepresentation if you wanted to argue that the shopkeeper made a misrepresentation about the facts, but it would have to be innocent, because there's nothing here to suggest that she knew. And your remedy in that case would be rescission, which is undoing the contract. So that would mean he would give the phone back and get the money back, essentially a refund in this particular circumstance. Yeah, I think there might have been a variety of ways this question was answered, but a good answer would consider both innocent misrepresentation and mutual mistake. For those of you who have the textbook, and for those of you who don't have the textbook, you can still photocopy up to 10% and not breach the Copyright Act. There's a really lovely summary at the beginning of chapter 6 of all the different types of mistakes and misrepresentation, and then it has next to that what the remedy would be, what remedy is available. I think that's definitely worth you having a look at, and then of course you go back and check which particular cases help you. So mutual mistake would be the Houlihan case that you would be looking at. Okay. Do you want me... I think it's clear for you. So the beginning of chapter 6, if you don't have the textbook, just ask your friend. I'm sure they will let you borrow it, but not for the exam. All right. Now, does anyone have any questions about that one? Okay. All right. C, did you do this one in tutorials? This was another question where the students who figured out the legal issue, most of them got HDs. So I had a lot of students who got like 5 out of 5 or 0 out of 5. So knowing the course material and identifying the legal issues can really make your life a lot easier. So, and there's a case as well that helps you. So which piece of legislation would you be looking at for question C? Sale of Goods Act, excellent. And which provision, if anyone wants to have a go? Section 23, this is about passage of risk. And when ownership transfers, really. And there's a case. I might just go back here for those of you who want some notes. I think you did do a tutorial question on this. Section 23, passage of title 23. In fact, would you like, I might just do an answer for you just for this particular one, just to show you how simple it could be in an exam scenario. So the question we've got is, Audio Plus received a consignment of mobile phones from phone company, and it said on sale or return by 1st of June. Sarah decides on the 15th of May to return some mobiles, but she doesn't tell them. She posts the mobiles on the 1st of June and they are received on the 5th of June. Phone Co refuses to accept the return. Okay, so you're going to look at and you're going to also look at the Atari Corporation case as well. I'm going to write where it is in the textbook. Please do not put that in your exam answer. Okay, textbook is not legal authority. So I'm just going to put where it is at the moment in case this is something you need to refresh. Now, you don't need to write the application. You could probably, if you're in a rush, you wouldn't even need to write the word rule. You could just write section 23. Okay, so let's look at Atari, which is at 8:14. Oh, it's not 5.2, it's 4B. Sorry, I think I've written the wrong thing there. 4B. Okay, so you need to give notice of rejection and it has to be within a reasonable time. So whereas, I'm just reading out 4B for you now. Where a seller delivers goods to a buyer on approval or on sale or return, property passes. The first scenario is in A, and in B, which is relevant, where the buyer retains the goods without giving notice of rejection after the fixed time set for return of the goods have expired to, or if no time has been fixed after a reasonable time has expired. So just to go back to the exam question, property passed either when 1st of June passes or if Sarah gave them notice before that date of rejection, okay? But because she decided that she was going to reject them but didn't tell them, when did they actually find out she was going to reject the goods? What date? The 5th of June, okay, which was too late. Okay. And then you would use EB Games Atari. In that case, they gave notice before the equivalent of 1st of June, but they weren't actually delivered and received by the company by that date. But because the notice was given before that date, the court said the goods had been rejected. So this case was different to the Atari case. You would distinguish it from the Atari case. Does anyone have any questions on that? Okay, so that would have been enough of an answer to probably get at least a 4 out of 5, probably a 5 out of 5, okay? That's how simple it can be sometimes, not always, okay. All right, let's look at duress. Did we do this one in tutorials? I can't remember, I don't think you did. Sam's employed by Audio Plus. Sam has to sign up 5 people to meet his sales targets. Jesse enters the store and he tells him, sign the contract now or I'll kill you. Jesse signs, I'm glad some people are laughing, exams can be fun. Jesse signs a 2-year contract and he wants to know if he's bound by the contract. Okay, so you probably have a gut instinct without the law. What do you think? Is Jesse going to be bound by the contract? No. And there's 2 different reasons why he's not bound, or 2 different laws. So what is the law in contract that says he's not bound? What do you need for a contract to occur? Consent must be freely given. Okay. Do you think consent has been freely given here? No. What is the legal term we'd use for what is happening here? Duress. Excellent. And the case for duress? There's a few cases, but there's one main case. Barton and Armstrong. Is this a PDF? I think it is. Oh no, I could do it. Okay. So I'm just writing the issues for you. Duress, Barton versus Armstrong. Contract. You'd put in your application, you would say Jesse's consent was not freely given, therefore contract can be rescinded. Okay? All right. Now there's another area of law that would also, so this I think I gave probably a 3.5 out of 5 for that answer. If you wanted to get 5 out of 5, there was another thing you needed to realise. Not many people worked it out, which is why, anyway, section 50, Australian consumer law. And that's a prohibition against harassment and coercion, okay? You'd say section 50 provides or prohibits harassment or coercion, holding a gun or threatening to kill someone is clearly harassment or coercion, therefore the contract can also be avoided. See, why is that not working? Oh, it's on there. Okay, cool. All right, I thought that was a relatively easy question as well. Hopefully you did too. Okay, should we take just a 5-minute break and then we'll keep going? So if you want to come back in 5 minutes, please do. And I'll go through the rest of the questions a bit quicker, so don't worry, we'll definitely get through some more than just 2018. Which question are you talking about? The Barton and Armstrong or the Atari? Yeah. There's your application.
That's it. You can just give it.
You could probably say that I did read a little bit about the law out. Like you could say what Rule 20. Yeah, I think that's probably enough. As long as you covered off what the rule was in 23(4)(b, that'd be enough. This one actually lots of people didn't get. So sometimes if it's a very not esoteric, but quite difficult question, simply identifying, like the answer is simple, but what is complicated is knowing that is the answer and that is the law to apply. Do you get what I mean? I think but maybe the only other thing you would add long as it's clear to your marker and your marker's not getting lost in it, you can do what you want. There's no strict format. As long as it's clear. Who was next? No worries.
Should application in this format, like listing all the points, or should we write an essay about that to compile all this in one paragraph? Doesn't matter. Doesn't matter. Okay.
That's all right.
Thank you.
Do you have a question?
No, just the same.
Sorry to sit down, my feet are tired. Did mention at the end of the you get me the text? I can tell you where it is in the textbook. It's at the end of the week. I think it's week 10, probably. No, we're intellectual property. Oh, week 9 then. Yeah, I think. I can only really tell you where it is in the law right now. Harassment and coercion. Okay, let's keep going. You did this one already quite recently in a tutorial regarding agency. You also did B. I can come back to this perhaps if you're still got questions, if there's time at the end of the lecture, but if I move on to this 2017 exam, you'll get a bit more useful commentary. So this one about the blog, you've also already got from the tutorials, although someone said to me this afternoon their tutor didn't have time to go through it. Did anyone not have this question dealt with in their tutorials? You all got it? Yeah? Okay, good. One student did talk to me today about the EMI songs and using a substantial part. Really, the secret to answering this question well was to identify the relevant case law. Like, obviously, you needed to know the elements of the Copyright Act and that Section 10 applied. It was a literary work, but you definitely needed to know the desktop marketing systems case and the other phone directories case like Telstra and ICE TV. And both of them had copyright in that work. Okay, now what about Mariam working in real estate? Can I get you guys up the back just to finish your conversation outside, if that's all right? Thank you. So this question, we actually let students handle it one of two ways and still pass, or perhaps even do much better than a pass. You were told specifically not to look at the Sale of Goods Act or Australian consumer law. The two things that would have been relevant here were negligent misstatement or, does anyone else want to have a go? Just take a moment to look at it. I think we did this in tutorials as well. But if you don't think we did, I'll go through it. So Mariam works in real estate in a regional area. She visits the Audio Plus store and tells Sarah, I need a telephone with excellent reception so I can use it in regional areas. I can't afford to miss a call. Please tell me what I need. Sarah recommends a telecommunications provider and Marion signs the contract. A week later, she's travelling through a small town and she misses an important call because her mobile has no reception. As a result, she misses out on an opportunity to purchase a property that would have made her a lot of money. Okay. So if you were looking at it in terms of negligent misstatement, which is talked about at the very end of chapter 25, I think, you would say that the elements of negligence had been met because Sarah is the manager. She's got an expertise. She's an expert in telephone. She's an expert in which providers provide the service. And so it was reasonable for Mariam to rely on that representation and enter into the contract. Okay? But the problem for Mariam would be with damages. Why do you think she'd have a problem getting damages? What test do you need to apply to work out what damages someone's likely to get? Causation and remoteness? Yeah? Probably wouldn't work for her here. Okay, it'd be hard to say that simply because she missed a call, she missed buying a property and the property would have made her a lot of money. Okay. I'm not assessing you on negligent misstatement in the exam, so I'm not going to spend any more time on that. But you might also look at the collateral contract case. I think it was the Van der Eschert and Chappell. I'll just find that. Does anyone remember what happened in that White Ant case? Or do you remember what a collateral contract is? Yep. Yeah, excellent. That's a really great description. So the normal assumption, isn't it, if you have a written contract, even if it's not a written contract, but we could assume, I think we can assume this is a written contract because she's entered into a mobile phone contract. So we assume that all the terms of the contract are contained in that written contract, okay? And that's the rule in Lestrange and Grab. Now, what does Mariam want to say is also a term of the contract? She's going to want to say that a term of the contract is that the phone provider will work. The phone will work. She will have reception in regional areas, okay? So the only way that she can do that is if she can show that that statement was a promise and a separate contract, and her consideration for that first contract was entering into the second contract, okay? And I'll just put the case up for you. So there's a test that you have to apply, and that's in the textbook and also in the Chappell case. I'll just put the paragraph number. Again, do not put a paragraph number in your exam. Okay, so she would have to, and you apply your application with your rule, okay? So you could say that Mariam will have to show that the promise that the phone will work in a regional area is not contradicted by the written mobile phone contract, and that it's not one that would ordinarily be found in the main contract, and she needs to show that Sarah's recommendation is promissory in nature, which may or may not be made out on these particular facts. Okay? Right, and if she can show that there is a collateral contract, then she can show that Audio Plus has breached the term of that contract because her phone's not working in a regional area. Okay? All right. Yeah. Yeah, and I think that's a really good point. So you would need to talk about that in your application. And I think you could possibly conclude either way. But you could say all we're told in the facts is that she's provided a recommendation. Is that promissory in nature, or is it just an opinion? Okay? And I think you could go either way. Possibly it isn't a promise. Of the contract? Yeah. Well, yeah, sure. So the problem here is so this is actually an example. So when this question was written, when I designed it, I was thinking of negligent misstatement. Okay, so that's why some of the language is not that clear in terms of promises. But a couple of very good students also thought, well, maybe this is a collateral contract. And I looked at their arguments and I thought, yes, it could be, but it's a bit vague. But the reason I wouldn't just jump in and say, is it a term of the contract, is the law is not helping you with that. Because if we assume this is a written contract, what are the assumptions we're told we have to make if there is a written contract? Applying the parole evidence rule, you have to assume that if the parties have gone to the trouble of writing down what they've agreed, that's it. That's their agreement. Okay? So Mariam is not going to be able to argue that's a term of the contract, because it's merely a pre-contractual statement. Yep. Okay? All right. Now, I don't think you've done this finder keepers question. I think you did one with Miss Scarlett. We might just do it really quickly. Bella visits the store to buy a mobile phone case. While she's browsing, she finds a diamond ring on the shelf. With the cases, she gives the ring to the manager. Advise Audio Plus. So what would you tell Audio Plus they've got to do with this ring? Find the true owner. Excellent. Okay. So the obligations that Audio Plus have are listed in Waverley Borough Council, which I don't seem to be able to spell. It is an exam, so you could just write Waverley. Oh, gosh. Okay, so they have obligations to look after the ring, to find the true owner, and so on. What about, do they need to give it to Bella? Okay, so Bella's done the right thing by handing it to the manager. They both have an obligation to find the true owner. Who will have the best claim if the true owner can't be found? Everyone's cheering for Bella. Okay, so if you were going to say Bella had the best claim, you'd be citing the Amory and Delamere case with the chimney sweeper. Okay, the person who finder has the best claim, although there are a number of exceptions to that. Bella's not working. I think she's a visitor, so you don't need to talk about any of the employment cases. There's only really one scenario where Audio Plus will have a better claim than Bella. What would Audio Plus need to show in order to have a better claim than Bella? Yes, so if they can show that they are exercising control and dominion over the space, you might mention the Bridges and Hawksworth case where the roll of banknotes was found on the floor, and you might also mention Parker and British Airways. There's not really anything in the question to tell you whether Audio Plus has control over the space. So it would be enough for you in your answer just to say Audio Plus will not have the best claim unless they can show that they're exercising control and dominion over the space. And of course, in all circumstances, the true owner has the best claim. Okay, let's do some 2017. And we can do some 2016 as well. Let me just see what I've got here for you. Slideshow from beginning. Given the time, we might just start with putting some key issues in, and then we can go back and give you some more law. Key issues and law. So, let's do 2016 exam 2B. I'm not sure that I have put this one up yet for you. Would you like to do this one? This is a Trade Practices Act one. Okay, so Erin's got a Halloween cake making business. It's Halloween next Wednesday. And she's registered Elm Street Cakes as her trademark to distinguish her cakes from her competitors. Her business is successful for a number of years, and then she goes back to uni in 2012 and doesn't operate her business again till 2016. While she's looking for a domain name for her website, she's upset to discover that Li has used Elm Street Cakes as his unregistered trading name. So unregistered means it's not registered under the Trademarks Act. For his wedding cake business. What action can Erin take to protect her interests? Okay, so what can you do if you have a registered trademark? I'm wondering if, okay. So I'll just put a couple of notes there. I'm trying to give you as much content as I can before we run out of time. So, if Erin's the owner of a registered trademark, she has exclusive rights to use that trademark. Is that a little small? You're all young with young eyes, but let's just make it bigger. Okay, to use that trademark in relation to the goods and services for which it was registered. Okay, so if she registered in relation to cakes or food, for example. Okay, so that's section 21 of the Trademarks Act. Okay, so someone might have infringed it. You see how I'm combining the law and the application here? Okay, so in your application, so you sort of got the law there and a bit of application, but in your application you would then need to talk about whether you thought it was the same or deceptively similar. Okay, so the name does look very similar. They're both in relation to cakes, so they're in the same class of goods, although whether Halloween cakes and wedding cakes are the same thing is another issue, although in terms of class of goods, they would be the same. But there is a provision that might get Erin in trouble. What are we told about Erin and her use of the trademark? Is there a period where she wasn't using it? Okay, so Section 92 of the Trademarks Act provides that you can apply to remove a trademark for non-use if it hasn't been used for 3 years. So Erin might be at risk of a Section 92 action. So possibly Lee G's use might not be infringing the trademark if he applies for non-use and then himself applies to register the trademark. Okay, so Section 92. Okay, he would have to show that she hadn't used it for 3 years. Okay, and then if we move on from trademarks, there's another area of law that Erin might be able to use to assist her. Has anyone got any ideas? It's not trademarks law, it's not intellectual property law. But if you're thinking someone might not be able to get protections under the Trademarks Act, what might they be able to get protections under? Section 18 of the ACL. Okay. That wasn't necessary to talk about here because she had registered the trademark, okay? But if she hadn't registered the trademark, or if Lee G wanted to bring an action, potentially he could do it under Section 18. Okay, you'd be looking at... so it's really more of a note for you. It wasn't that necessary to talk about it in this question. And you'd look at the Taco Bell case. Okay. So you'd need to be thinking, I think Section 18 probably wouldn't work. So remember Taco Bell, you have to look at the section of the public who might be misled or deceived by that conduct. And I don't think the people who are looking for a wedding cake to purchase would be the same people who are looking for a Halloween cake to purchase. So but I did have good answers that could argue either way on that point. But again, if you decided that Erin could bring action under the Trademark Act, you didn't need to look at Section 18, but you might look at that for Lee G. Okay, does anyone have any questions on that one? Okay. It's a fairly complicated question. I'll just give you some legal issues. What time is it? We've got another half an hour. Okay. All right, let's just make this large. Okay, so this is also in the 2017 exam. Elizabeth books a tour of local wineries for herself and 9 friends. The package is described as all-inclusive 5-star luxury, included travel on a luxury coach, guided tours of 4 wineries and lunch. She signs a contract and pays a 50% deposit. But there's been bushfires and a number of roads are closed. Elizabeth calls Shiraz Tours the day before and asks if it will be rescheduled, and the tour guide said, "It's all good, I'll see you tomorrow," and Elizabeth transfers the rest of what she owes. And then they turn up for the tour, and they're not in a luxury bus, they're in a pretty ordinary bus, and they only go to 1 winery, not 4 wineries, and there's not enough wine. Everyone is very unhappy. And they find out that Shiraz Tours knew about the fires. Okay, so can Elizabeth bring any action against Shiraz Tours in contract? Let's just jump to the second part of that question. Can the other members bring an action in contract? So can her friends bring an action to a contract that they weren't part of? No. Okay, what's the rule? Privity of contract, okay, and Jackson and Horizon Holidays. Excellent. So the answer is no. Privity of contract. obviously there's more to the answer than that. Okay, what about Elizabeth? Do you think Elizabeth could bring action? You really just need to be looking at the law related to breach of contract, okay? So what were the terms of the contract? What was promised to Elizabeth? Is that what in fact she received? Okay, so you go back to the facts and consider what was given and what was not given. And you would also note, so just talk about breach and then also talk about damages. Now normally you can't get damages for distress and upset unless the core purpose of the contract was enjoyment and relaxation, which you would argue was the core aspect of the contract here. Okay. And then there was a defence, which wasn't that strong a defence, but a defence nevertheless. Is there a defence that you think they might argue? So the reason the contract couldn't be delivered was arguably because of the bushfires. Bushfires weren't out in their control. What happened? What area of contract might you look to if something happens that neither party anticipated? Frustration? Okay, so you would also consider defences, frustration. Okay. You know the elements of frustration. Was actually relevant for the problem paper, and I've put the elements there for you in the answer guide. You might argue that the contract didn't meet the actual requirements of frustration. Okay, now I won't go through frustration in any more detail because you do have the answer guide for your problem paper. Now, what about implied terms under the Sale of Goods Act or the consumer guarantees under consumer law? Does the Sale of Goods Act apply here? I'll take you back to the facts. Is there a contract for the sale of goods? No. Okay, the only sort of good that they're getting is they're getting a lunch. Okay, but you could argue that the lunch was incidental to the service. Okay, and you could use the E and Australian Red Cross Society case on page 229, and also the definition of sale of goods. Okay, so your answer would be no, she can't take any action under the Sale of Goods Act because this is not a contract under the sale of goods that relates to goods. And really good answers said the dinner or the lunch that was provided was incidental to the product, which was a service. Okay, what about the ACL? I think so, yes. We'd be looking at section 60 and 61 in relation to services. Be careful that you, in fact, did mention ACL provisions that related to services, not ACL provisions that related to goods, okay? So we'll be looking at section 60 and 61. ACL, which provides that there's a guarantee that services provided to a consumer in trade or commerce will be rendered with due care and skill and will be fit for purpose. And the purpose here was, relaxation and enjoyment. Okay. Damages for breaches of service are found in 267 to 270. This was, I think, a reasonably difficult question. A lot of students sort of got the basic stuff done, but not all of them got. So a lot of students worked out the Sale of Goods Act didn't apply, which was fantastic, but then the ACL provisions they talked about were the ones that related to goods, not to services. So even once you've worked out SGE doesn't apply, If that's because specifically that's not a good, make sure you're looking at the right provisions in the ACL and giving me ones that relate to services. Okay. I think we've done a fair bit of incorporation of terms, so I might just keep going. But I'm happy to put more key issues up next to these ones that we jumped through. Okay. Copyright with Professor Plum. What question was this? 2017 2C. I don't think that's right. Oh, I'm looking in 2016, sorry. I think this was from a supplementary exam, maybe. Oh no, here we go. Okay. Do you want to do a copyright case, or do you feel like you've got enough? I think everyone just wants to go home, wants the exam to be done with. Okay, so we've got Professor Plum sharing his ideas for some new puzzles with Colonel Mustard. Professor Plum has not written these down, they're just in his mind, and he asked Colonel Mustard not to tell anyone. But Colonel Mustard then goes and writes them on his blog. Professor Plum is worried that he can't use the ideas for his new puzzles because people will already know the secrets to his puzzles. The idea of the puzzles is that people have to go in an escape room and use the clues to get out. So if the answers are being published on the blog, that's a pretty big deal for Professor Plum. Now, first off, does the Copyright Act apply to Professor Plum's idea for a puzzle? No. Okay, because copyright only applies to the formulated expression of an idea, not the idea itself. Okay, and your case for that is Donoghue and Allied newspapers. So there's no breach of copyright here for Professor Plum. Okay, so some students, that's as far as they went and they still got a pass. They might have even got 3 out of 5. There's some slides I taught you just today at the very beginning of the lecture before I got into the week 12 revision stuff about confidential information. So this is what a HD answer got. HD answer realised that Professor Plum might be able to bring an action for breach of confidence. Okay, he told Professor Plum, he told Colonel Mustard, something in confidence. It was in a secret environment. He promised him not to tell anyone else. He's suffered a loss, so there's been a detriment. The test is in the Coco case, which is on the slides. And so he could seek damages from the court, and if the loss is proven, he might also get additional damages. An injunction is not appropriate here. Why is an injunction not appropriate? It's too late, okay? The material's already been published on the website. Has anyone got any questions about this one? Okay. This is another negligent misstatement question, but I'm not going to test you on negligent misstatement, so you do not need to worry about it. Also not statutory interpretation. And we've done semester 1, 2018. Okay, so what do we want to go back and do in more detail? Okay, maybe we can do some more 2017. Do you want to do that? Or does anyone want me to go back over any 2018 questions again? There's quite a lot of 2017. Give me a quick moment. Okay, I'm just going to pull up the 2017 paper from Waddell. Okay, shall we do Professor Plum with the Facebook page? 2017. Okay, so you're told not to discuss Section 18 of the Consumer Law, but you certainly could have. We've got Professor Plum creating a fake Facebook profile. My kids love the puzzle room. And he's also got an advertisement promising $1,000 to any person who can complete puzzles in 15 minutes of less, although he has no intention of paying the money. Okay. Sorry. I can hear everybody yawning, I'm sorry. Okay, so what area of Australian consumer law might you be looking at here? Section 29. Perhaps 29(1)(e), because he has a false advertisement, a false testimonial. It would also probably be okay if you looked at F. Okay, so saying the kids love the puzzle room, we'll come back to soon, without a real name would be a breach of those provisions. What about the prize? Is it an offence to promise a prize that you have no intention of paying? Does anyone know what provision that is? Section 32, ACL. Have a look at 11.52. There's your standard whole range of remedies. I can just pull them up now for you if you want. Okay. Would you like to, because I think we've probably nearly done most of this section already in tutorials. So what we could do for Professor Plum, just because we've got enough time, is might quickly look at it as though you were going to look at Section 18, because I haven't done any questions on that today with you. So misleading and deceptive conduct under Section 18, even though you were told that you didn't need to do that. Okay. So Section 18 starts on 338. So let's just pretend that we have been asked, has Professor Plum engaged in misleading and deceptive conduct? Maybe that's not the best one. Sorry, just give me 2 minutes. I might just write the elements for you of Section 18 as a reminder. And then I might just go to questions. Okay. So this is already in your textbook and in your notes, but I just want you to be aware of it. So conduct that leads members of the public in their capacity as consumers of goods and services into error or is likely to do so. And then there's many, many examples that you should, I think, review before the exam, which is at 11.13 of particular types of conduct that the courts have found to have contravened Section 18. Okay. Now, you always need to talk about the Taco Bell case, and then there's a few other cases that I've mentioned as well. But Taco Bell, Taco Bell tells you need to look at the particular consumer. So in the Taco Bell case, it was looking at consumers who want to go to a Mexican restaurant in Bondi. Okay, and those particular consumers who want to go to a Mexican restaurant, are they going to be confused if there's another Mexican restaurant of the same name? Okay, so you're not looking at any consumer who's going to a restaurant, you're looking at the particular consumer who's interested in that type of product. Okay, oh, sorry. All right. Has anyone got any questions about Section 18? Okay, all right. I think I've gone through everything I wanted to go through today. Does anyone have any questions from 2018 or 2017 that I haven't gone through that you would like me to go through? We still have 10 more minutes. We can do the agency question if you want with Beatrix and Torvin. We did do that in tutorials. Or we could do the Amelia case, which was about estoppel. Let me just go back up here. All right, well, sorry, let's do Mr. Green then, because perhaps you didn't do this one in tutorials. This is 2017 question 2A. Okay, Mr. Green has purchased tickets online to celebrate his birthday with friends. When they arrive at the venue, Mr. Plum tells them that the experience ends when the puzzles are solved or 60 minutes have elapsed, whichever occurs first. Failure to vacate the room on time will result in a fee of $50. This was not stated online. Mr. Green and his friends solve the puzzle in 45 minutes and insist on remaining in the room for the full 60 minutes. Professor Plum charges $50 to Mr. Green's credit card. Okay, what is your legal issue here? What will Mr. Green be wanting to argue is not a term of the contract? This bit. Okay, Mr. Green is going to want to say that is not a term of the contract. What grounds would Mr. Green have for saying that it's not a term of the contract? Okay, so it wasn't stated online, and when was the contract made? Online, okay, so the contract was made before they entered into the room. So the question is, your legal issue is this a term of the contract? Okay. Is Mr. Plum's statement a term of the contract? What's the general rule about terms? Do the parties need to know the terms before they enter into the contract? Yes, okay. Okay. Now, why wouldn't a collateral contract be relevant here? It's about the timing of the statement. Okay, so for you to even be considering whether you're talking about a collateral contract, that statement would need to be made before the contract, this primary contract was made. Okay, and statements that are made afterwards, none of the elements of the contract are there. Okay, there's no promises, there's no consideration from the other parties. And I've got a case for you for that as well. So just let me to write that out for you. Formation is a fancy word for making, I guess, the making of the principal contract. And I'll just give you the para number in case, again, you want to look at it. Okay, and do you think it could be an implied term of the contract? It's unlikely to be an entire term. It's not necessary for the contract. It can't be implied because of custom or trade use. Okay, so there's not actually, there's a little bit of law there that you could put in to say that there's not these other explanations for it. But really this question in some ways was easy because it was a very foundational issue of, well, what is a contract? When is a contract made? So you didn't need a lot of law to get a HD for it, but it was surprising how many students didn't quite understand. Oh, sorry, the majority of students did get it, but a lot of it, there was a significant cohort that didn't get it. So sometimes it's important just to go to back to the very first principles of what is a contract. Are the elements present? Okay, and so here the statement's made after the contract is made. There's no consideration. It's just a statement on its own. There's nothing to suggest that custom or trade usage means that you have to vacate the room after 45 minutes. So you can't imply a term either. Okay. I think you've done finders keepers to death. You probably feel like you're all ready to find something now. All right, does anyone have any questions or want me to go over any of the questions from 2017 or 2018 again? Okay, so there's a lot of consultation times next week and you can certainly email me. I'm going to be travelling for my other job on Monday, Tuesday. So if you're going to email, try and email on the weekend or I'll reply to you on Wednesday or late in the evening. All the best for next Friday. I'll see you then. Yeah, of course. Oh, sorry. Sure.